we have no real media in this state. Well, you have us.
It's really time for a parent revolution.
Never let a good crisis go to waste. That's what the left did with COVID in so many different ways.
Wind energy, especially offshore wind, is a big loser and just another government boondoggle.
Like, what's going on?
People are fed up. They lied to us then. They're lying to us now. They're assaulting our families.
What we do is we look at the lies of the left that they keep pushing out, that America doesn't work for black people. That is not true.
They want to now monopolize truth and say, truth is only what we say truth is. Damn the data, damn the science.
The key with science is it always needs to serve objective thinking. They just call anyone who challenges them a science deniers.
They're evil.
Shut up or we'll cancel you.
What we're going through is a cultural revolution.
This is big, and this is how change begins.
Ladies and gentlemen, boys and girls, welcome to the Ocean State Current Command Bunker. Now playing from in the dugout, number 37, Mike Stenhouse.
The U.S. Supreme Court today issued a ruling that may actually save the lives of our children. My guest, Attorney Gregory Piccirilli, is going to discuss with me the legal next steps that it's going to take to do just that, to save our kids' lives. Hey, folks, welcome to In the Dugout. Your host, Mike Stenhouse here. You know, following the horrific Pawtucket ice rink shootings by an obviously emotionally disturbed male who believed he was a woman, there's been a lot of talk about the need for increased access to mental health counseling. But in Rhode Island, how can we provide access to appropriate mental health counseling if access to appropriate mental health counseling is banned by law? And that's the case here in Rhode Island. 2017, state lawmakers passed a law that banned, quote, conversion therapy, basically saying if you're a mental health professional, social worker, or any other licensed professional in that area, the only thing you can counsel is to affirm that young person's delusions, if it's a minor. That's all you can do. You're not allowed to give any other opinion, any other diagnosis. You're banned from giving them the life-saving therapy and counseling they may need. Now, this issue we've known about for a long time, but it was all brought to a serious head with a guest I had recently on In the Dugout. His name was Michael Menard, and he has one of the nation's top entrepreneurs and businessmen, has done extensive research, and it is irrefutable that childhood trauma, which transgender transitioning is certainly one of them, one of the types of childhood traumas, that childhood trauma in almost every case can lead to early death or incarceration. Death from heart attack, suicide, addictions, the list goes on. But that burden, his book, Menard's book, Greater Than Gravity, how childhood trauma is pulling down humanity, basically looks at the science that confirms that these childhood traumas are such a heavy burden on the souls of these people as they grow and as they age and become adults, that eventually it pulls them down to the ground. They cannot carry that weight and the burden, and something bad, medically, criminally, is going to happen to them. We must provide appropriate counseling, because Menard also says that with the right therapy of counseling, I'll get into that in a second, that these traumas can be relieved. These traumas don't have to be the weight that you cannot bear and pull you down. And what's required is for religious leaders to step up and provide the first line of therapy, if you would, because a lot of people like to go to faith-based institutions for the love and spiritualness that they can only get from God. But then, these would be licensed people, licensed coaches that Mike Menard calls them in his program, which, by the way, has been adopted and acclaimed by other countries throughout the world. And the second line and the final line of defense is aligned mental health professionals who are further certified to deal. So this combination of faith-based and professional mental health counseling is a way to relieve this burden that may be caused by various childhood traumas. But like I said, that's not allowed right now in Rhode Island. So my guest, Attorney Piccirilli, is going to discuss what legal or legislative actions need to be taken to get this bogus rule in Rhode Island off the book. Colorado's law, similar law, was just overturned and stricken down by the United States Supreme Court. Rhode Island's law is almost identical. Rhode Island's law is now unenforceable and unconstitutional itself. So what do we do about that? We're going to talk about that with Piccirilli. But again, in Rhode Island, we some people call it grooming. Some people call it age inappropriate content. In Rhode Island, we expose kids, however you want to term it, at too young an age to divisive and heavy, burdensome theories and push them towards whether it's comprehensive sex education, whether it's transgenderism, whether it's just relations with adults, or whether it's mistrust of your parents. We're pushing kids and causing emotional instability, and then think about it, and then we ban the very therapies that might help them. So we have this double problem in Rhode Island, but today's Supreme Court ruling can help us with the second part, the treatment part, because individuals are suffering. They're emotionally confused, they're disturbed, and they need help. Look, this is not what we're here today. We're not happy about this ruling from the Supreme Court because it's one more piece of the woke agenda that's being chopped down or put away. No, we're happy about this because confused, gender dysphoric children now have the chance to be saved. Why would we want these kids to go into life and and have a higher chance of dying early than otherwise, or dying sooner? The myth that only by affirming these delusions can children be saved from suicide is completely backward, according to Menard in his book. He says by affirming these delusions, we're just placing more and more burdens, childhood traumas on these young children, and the impacts in their future lives will be even that much more severe. So this is why, according to Menard, we need this combination of initial faith-based healing, then combined with professional mental health counseling. But we can't have that mental health counseling unless we clear the way, unless we get this evil, as he called it, evil Rhode Island law off the books. So to discuss what our options are to get that law off the book, we welcome back to In the Dugout our good friend, Attorney Gregory Piccirilli. So he's back with us once again, our beloved attorney, Greg Piccirilli, who represents so many needy clients in so many areas where our government is infringing on their rights. Greg, welcome back to In the Dugout.
Oh, thank you, Mike. Good to see you again.
So the X, Twitter strings, text strings were kind of blowing up today as the Supreme Court made its announcement. You're an attorney who represents a number of clients related, with the whole transgender issue. We've talked extensively on this show about the Jane Doe situation, the attempted suicide situation in West Warwick. But we'll get into that later. But first of all, for someone who's studied the law on this extensively, this whole issue, what was your initial reaction when you heard, and explain to our viewers what the Supreme Court said?
Sure. Well, it's a good day for the First Amendment. That is really the impact of this decision. It's a strong reaffirmation in a day and age when people are trying to restrict people's free speech rights, not just in this country, but all over the Western world, certainly, which is something we're not used to. Certainly not something we grew up with, understanding how the First Amendment is supposed to work. But yeah, it's a powerful decision, and it is for the court, it seemed like it was an easy decision. It was 8-1. I mean, it
Yeah.
was not even close. The court just was able to reaffirm that when a anybody, including a medical professional, is talking, and this was about a therapist who wanted to be able to talk to her patients about options that they can, both affirming, if they came to her and said, I'm transgender and I want to affirm that, but I'm having difficulty with relationships, etc. She would work with them for that. If they came to her and said, I have doubts about my sexuality, she wanted to be able to talk to them about that as well. And that was what this Colorado law and many laws across the country, including the law in Rhode Island, that's very similar. It's called, conversion therapy ban. That's what it tries to regulate. It tries to regulate pure speech, pure talk therapy. The court distinguishes, for example, adverse physical therapies, like, people may remember when they used to use shock therapy to shock people who claim they were, were homosexual. They used to do electric shock therapy to convince them that they were not gay. I mean, that clearly is a barbaric practice, and the court distinguished that. That would be something appropriate for the state to regulate. But this isn't shock therapy. This isn't hooking people up to machines or engaging in any type of physical intervention. It's purely talk. And for the court, that made it really an easy case.
And I think the opening line here of the 8-1 majority ruling authored by Judge Gorsuch pretty much says it all. Look, this therapist, this Kaylee Childs, says, I don't go in with any predetermined goals or restrictions. I sit down, I talk to my client, I try to decide what's best, and then I recommend the therapy or course I think's best. So the Supreme Court says, yeah, similarly, we can't put any predetermined guidelines or restrictions on how you might counsel as well. I mean, if you really want to simplify it, that's basically what it's saying here, right?
Right. And interestingly, again, it got two of the three liberal judges, Judge Kagan and Judge Sotomayor, concurred in the case. And they pointed out that, in prior times when, for example, homosexuality was considered a mental disorder, back before the mid-70s, it used to be in the DSM as a mental disorder. Under the dissent's theory, the one judge who dissented, and under Colorado's theory, the state could have back then banned affirming therapy for people who were homosexual.
Right.
If you can ban,
just flip it, right? Yeah, just flip it.
It works both ways. If you
Right.
want to, if you're going to ban conversion therapy, well, you could also ban, in a different political environment, in a different world, you could ban someone who says, if someone comes to
Affirming
you,
therapy, yeah.
and again, and I think this applies, someone pointed out,
Great point.
it could have an impact on conservative red states who want to try to ban therapies that affirm transgenderism. And what the court pointed out was, if a therapist is going to talk to someone about a broad range of possibilities, it applies across the board. And that
Right.
is, if someone who genuinely feels they're transgender and wants to work through that, what's to stop the state from taking the reverse point of view and prohibiting that?
And to your point, Greg, and if you look at one of the sections I highlighted right here, you can, it's okay to regulate, but you can't regulate based on political viewpoint, right? That's, I mean, if it's obviously harmful to a person like shock therapy, yeah, that can be regulated. But when you're talking about something that's as subjective as political viewpoint, no, these professionals have an inalienable right to decide themselves how to speak, as it says right here.
Yeah, I mean, I found it interesting. There were two cases that the court cited. One was West Virginia versus Barnett. It's a case we studied in constitutional law, First Amendment law. It was back from during 1943, during the height of the Second World War. And Virginia had a law that required people to get up and made what was similar to a Nazi salute, professing their support for the government. And the court said you can't force people politically to get up and affirm something like that. The other case that they cited, that they distinguished, it was one of my old favorites, Buck v. Bell. They actually cited the case. Buck v. Bell was a case from 1927 that said that a state could forcibly sterilize mentally ill people. And I remember that really got me going during COVID, didn't it? Because they were justifying vaccine and other mandates based upon that case, which is disturbing. And the court again said that's outdated thinking, that does not comport to the First Amendment. So it was refreshing to see a strong First Amendment decision.
Yeah. And as you mentioned, not only did they talk about the practicalities of restricting professional speech in this case, but they also talked here in in Section D of their summary that it is a clear violation of First Amendment, which was the first thing.
That's a beautiful statement by Judge.
It is a beautiful statement.
Yeah.
So everybody, I'll leave it up for a while longer. But all right, so let's now talk about, well, in my opening comments, which you weren't on to hear, I had a guest earlier this week who's really studied the issue of childhood trauma. And these conversion therapies, this allowing children to believe there's something that they're not, is childhood trauma, causes trauma, and will affect, his research is irrefutable, will affect children later in their life. So I made the comment, all right, not only does this uphold, and allow for proper therapy, whatever that therapy is, to go forward, not only does it uphold and affirm the First Amendment rights, but in a practical way, I believe personally, you don't have to comment on this if you don't want, because you're a lawyer, and I'm the big mouth advocate. I believe that this will allow professional mental health counselors to save children's lives now, because in the case of Jane Doe, your client, her daughter was secretly transitioned, and she tried to commit suicide. That didn't save her life. That actually added to the burden she was carrying, trying to live that double life.
I think that's a good case for us to analogize to this decision. Think of that poor young girl who was struggling, first and foremost, was struggling with her own childhood trauma of sexual assault. Just really horrific things that were done to her when she was a young girl, and how that impacted her her view of her own sexuality as she was approaching puberty. Under this conversion therapy statute, if she went to a doctor or a therapist, and the therapist wanted to explore what might be, causing you to not want to appear as a girl anymore. Could it be because of this trauma that you suffered as a child? Therapists in this state have told, I am personally aware of therapists in the state that say we are prohibited by this law from even exploring that. Think about that.
And in daughter Doe's case, when she was what, like 5 years old, she was sexually abused by a relative.
Right.
So
yeah.
this young girl, who years later would try to transition, was obviously traumatized as a young person, and yet you're saying counselors even could not look into this person's background for that stuff?
They would say, they've said point blank, it is illegal for us in Rhode Island, under Rhode Island law, to even talk about it, to even explore it.
So my guest on Monday, this Michael Menard, called that evil. And I believe it's even more evil than I thought based on what you told me. I didn't even know it went to that extent. All right. So we've established that Rhode Island's law is evil. The Supreme Court has now established that Rhode Island's law is unenforceable and unconstitutional. So let's flip our discussion now to asking, what do we do about it? How do we get this evil law off the books? What are your initial thoughts?
Well, it's interesting because the beginning of the decision talks about, that difficult issue of standing, the issue that even most lawyers can't understand, never mind the average layperson. The woman who sued was a therapist. She argued that she had standing because she had been threatened by the state of Colorado's medical licensing with fines, license revocation. Colorado, at the beginning of the decision, the court notes that Colorado, all of a sudden, for the first time, when they realized they're going to lose and lose big, started arguing at the Supreme Court, oh, no, we had no intention of enforcing this law against her talk therapy. It's only if she wanted to do something like hook the kid up to an electric shock machine. That's what we're really trying to regulate. And the Supreme Court wasn't buying any of that. Now, having said that, Rhode Island's law is interesting. As far as I can tell, no doctor or no medical professional has been disciplined or even threatened with discipline by the Department of Health. In fact, and we talked about this, a curious thing about the statute, it was passed in 2017, I believe, and it required the Department of Health to issue regulations to enforce it. The Department of Health has done nothing. They've issued no regulation. Maybe.
All right, so just to be clear, the Department of Health, even though they didn't issue those regulations to clarify everything and the processes, they are, quote, the enforcement mechanism of that 2017 law in Rhode Island, right?
Right. And so for someone to challenge the law, so now the law is there and it's unenforceable. It's kind of like during the Roe v. Wade era, when Rhode Island had one of the strongest anti-abortion laws in the country at the time, back in the early 70s, because we were one of the most Catholic nations in the country. When Roe v. Wade came down, Rhode Island never repealed their anti-abortion statute. It just sat there unenforceable. And I don't know that anybody actually filed a lawsuit to declare it unenforceable or not. Everybody just acknowledged that it was unenforceable and wasn't, no doctor was going to be prosecuted for performing an abortion. Well, so the question would be, if there was a challenge to this law, one of the first things we'd have to find out, and whether the Department of Health would even respond to something like this, is, have you enforced it? Do you intend to enforce it? Or do you acknowledge that it's unenforceable?
Okay.
If it says we acknowledge it's unenforceable, then probably a lawsuit's not necessary or even appropriate. The court might say that, it's not a case of controversy. Again, it gets into the kind of the weeds of
all right. Let's get into the weeds, and we're welcome. I didn't expect her to join us, but we're thrilled that one of our other law center volunteer attorneys, Suzanne Cienki, has joined. Sue, move over so you're in the middle of your picture. The camera's off center. Has joined us. We have another attorney here. Yeah, move over a little, Sue, to your right. Yeah, there we go. So we're discussing now what we do to get this obviously now unenforceable and unconstitutional law off the books. Do you have any initial thoughts?
You'd have to find a therapist, first of all, that was harmed by the law. Because as Greg said, you wouldn't have standing if we couldn't sue them. For what? It really is an unenforceable law. So is there any harm and controversy being created by having this law in the books? No. There's lots of laws on the books that you can't eat peanuts in church. They're ridiculous. They're not enforced. So I
can't eat anything in my church, so I don't know.
Yeah. We can eat cheap.
So is it really that complicated that in order to petition the government, we'd have to file a lawsuit and find a counselor who's been aggrieved by this?
Yeah, well, it's just not an enforceable law at this point. Like it's
that's what I mean. Didn't the Supreme Court just do all our work for us? Why do we have to go back and do all that work again?
You don't have to, because it's not going to be an enforced law.
But it's still going to be on the books.
Yes, like I said, there's an
interesting twist to this.
Yeah.
During Roe v. Wade times, doctors would try to sue to declare a law invalid, unconstitutional, that threatened a mother with prosecution. And the courts would give the doctor standing, kind of a supplemental standing or derivative standing, because their argument was if the woman herself would not, if every doctor was just afraid to do an abortion, even if they weren't threatened with prosecution, that they're being denied a constitutional medical benefit. Here, someone might make the counter argument. If I'm a parent of a child who's struggling with gender identity, and I start calling up therapists, and every therapist I talk to says, I don't do neutral, and again, I think the proper term is neutral therapy as opposed to gender affirming therapy. I don't do neutral therapy because the law in Rhode Island says I can't. Well, haven't you read this case, Childs versus Salazar? That's unconstitutional. I'm not a lawyer. What do I know? All I know is I've been told by my medical my insurance company, the AMA, my license, people that I work with, if I do this, I could be jeopardizing myself. The parent in that child could be effectively deprived of their constitutional right to have talk therapy.
So could Jane Doe have a case here because her daughter, as we understand it, was sent to, I think it's called Thunder Miss, some kind of counseling service provided by the Rhode Island Department of Education that had no choice but to affirm this young girl's delusions, and they did, and she would later try to commit suicide. So to Sue Cienki's point, if somebody needs standing, does it have to be a therapist or could it be a child or parent?
Right.
It's an interesting theory.
Okay.
And it would be an interesting argument, and I would look at the old Roe v. Wade cases where everybody, people want to forget about that now, but there was a very broad understanding of standing under Roe v. Wade.
If we found someone with standing, who would a lawsuit be filed against? Who would be the defendants?
Well, like I said, I think the first thing we'd have to do is find out from the Department of Health whether or not they would be willing to say that they would not enforce the statute. If they put a statement out and said, we recognize the statute as written is not enforceable, at least as it relates to talk therapy, then they're on record of having said that. If they say no, we're going to, we still think it's valid, or if they're silent and refuse to say one way or the other, then that might create a case of controversy that could lead to standing.
All right, so I'm going to play devil's advocate here, I'm going to push the issue. Even if they say that and say I'm not going to enforce it, it's unconstitutional, we're not going to do anything about it, just like the eating peanuts in church thing. But I want this evil law off our goddamn books in this state. Is that enough to remove and repeal that chapter of state law? Or will it just sit there and be ignored?
I think it sits there and is ignored.
All right. So it would take a lawsuit to. All right. So there's a few things that happen. The Rhode Island Department of Health said we're going to ignore it. We're not going to enforce it, and effectively neutralizes it. We'd have to sue somebody to get it off the books, right? That's the other path, right? Regardless of what form that takes. Now, I'm thinking there's a third option too. Since the legislature wrote the initial legislation, could there be legislative action to repeal that law, and would that be enough?
Good luck with that. I think you might be the one that told me that the statute was enacted by unanimous consent.
Yep.
How much?
No, wait a minute.
How much?
Well,
how much does that General Assembly have the guts to do the right thing and repeal the law? I'd be shocked.
It's insanity here.
I would be shocked if anything. Right. I think they would double down on the, and try to make it even more enforceable.
But if it's unenforceable and it's unconstitutional, I mean, it's no longer a emotional, political, or moral issue. Isn't it just a straightforward legal issue now? The Supreme Court says this law is unconstitutional. I mean, it removes all
You would
other
think.
You
arguments.
think that's
doesn't
going to
it?
stop these people?
Yeah, you would think. Forget it.
All right.
This
Forget
is-
what they will do. Would passing legislation remove it from the books?
That would be the most logical,
Yep.
coherent. Look again, Roe v. Wade. The law sat on the law of Rhode Island sat on the book for decades, unenforceable. The anti-abortion law, and then in 2019, when it looked like the Supreme Court was going to overturn Roe v. Wade, what did the General Assembly do? They passed a law not only reversing the anti-abortion statute, but basically codifying into law that abortion up to birth.
Right.
So when they're motivated to go the way they want to go, boy, they can go that way real fast. But I don't see any motivation in this state or in these people to.
No, I agree. They're not. Yeah, it's hard to imagine they would do it. But I'm saying, but if they did, it would be legal.
You want to be you want to be the legislator that pushes this and has your campaign offices firebombed?
Especially on Trans Visibility Day.
Yeah.
Let's wait until that day and introduce it. Yeah.
All right. So option 1 is ignore it, not enforce it. Option 2 is sue to remove it. Option 3 is to legislate to remove it. Are there any other options out there given the Supreme Court ruling this morning?
Well, I think it's kind of wait and see at this point.
Yeah.
I'd be curious if there was a therapist out there who had the intestinal fortitude,
Merity,
to want to pursue something, who wants to engage or does engage in this neutral talk therapy, but has been threatened in some even in an informal way, if they wanted to pursue it. Love to talk to you. Give us a call.
Yeah, I'd be shocked if you found a therapist. I mean, I think that the type of people that gravitate towards that profession have been so indoctrinated by the left that they probably think what the Supreme Court has done is awful.
Yeah,
well, it is the law. It is the law of the land now, and people can debate it. But and we can have that debate. But that's the purpose of this: is what are the legal, implications if this, what that, and it's a big if. I get that, but so I want to stick to. That's why I want to stick to what are the legal courses that could happen here, and we can save all that other debate. To me, now is superfluous. It's over. The Supreme Court has ruled it is the law of the land. Agree?
Absolutely, and I think this is, it builds on the Mirabella versus Bonta case that just came down. Again, it was on the, emergency shadow docket, but it signaled, the McMood case from last year. I mean, the Supreme Court is definitely moving in a very strong way towards putting some sanity back in the law.
Common sense
Back into this. I think they've seen the absurdities to which some of the levels have gone, and they're trying to be a bulwark against that. Like I said, before you get on, great day for the First Amendment. I mean, I don't know if you had a chance to read through the decision yet. Just really well written. Of course, Judge, agree with them and disagree with them in the Bostic case with the Title VII and transgender issue, but man, he can write, and he really wrote well.
I haven't gotten through the 35-page dissent.
I can't even bring myself to read that.
I have 35 pages. I thought it was a misprint. 35-page dissent. I didn't even think she knew that many words.
Well, she's got like about a dozen.
That's a whole nother.
She has a dozen law clerks.
Ketanji Jackson Brown. That's a whole nother issue for another day. All right. So let's wrap up. Can we say this? That Attorney Greg Piccirilli, Attorney Suzanne Cienki, your other law center volunteer attorney who's out of the country right now, Giovanni Ciccione, can we say that the law center at the Rhode Island Center for Freedom and Prosperity is going to explore the 3 legal options we looked at, as well as any others that we might think of, and hopefully try to inspire some action on this? Can we say that?
Absolutely.
And if there's such a mental health counselor or parent who feels they might be aggrieved by this, we ask them to come forward?
Yep.
Yes, I mean, depending on the facts and the circumstances of their case.
Yeah.
Yeah.
And if we did file a complaint, what would that be seeking for an immediate declaratory judgment?
Yeah, it'd be declaratory judgment and an injunction against the enforcement of it. Because it involves the question of whether a statute is constitutional. The law in Rhode Island requires you to name the Attorney General or serve the Attorney General as a party. But the case would be against
The Department of Health.
Department of Health, in two parts, declaring the statute.
And the Attorney General, right?
And the Attorney General most likely would defend it anyway. So that he would just step into that role. Be curious to see what, again, the Attorney General in Colorado, they started wavering pretty quickly. Oh, no, we're not going to prosecute. We wouldn't prosecute this. Well, we have this email saying that you would.
Yeah.
So be interesting.
How long would a complaint and a lawsuit take for all that to happen? What's the fastest?
I already got it written, Mike. I'm ready to file it today.
No, but for the court to act, it could take years, right?
Oh, yeah.
Yeah. Again, it depends on a lot of things. Like I said,
my point being, legislative action, we could have it done by the end of this legislative session. So that would be the fastest, most expedient way to totally expunge this stuff.
I love your optimism, Mike.
Yeah, there is no way that any legislation would pass this year. Absolutely.
Can you even get somebody to sponsor such a bill?
Yeah. It just.
It's not going to be the law center, but it's going to be Mike Stenhouse who's going to look for somebody to sponsor that.
No, they won't, and the Senate will not accept any new legislation anyway. They're done. The House.
But what I don't understand, how can they say we're not going to comply with the United States Supreme Court? How do they say that?
Well, they're just going to say it's not enforced. So, again.
All right, we'll see. See, this is the blueness of Rhode Island. The woke agenda coming right at us right here. It
doesn't align with our values, Mike. Geez,
where have I heard that before?
not our values. I'm not really sure what you have to have. That.
I remember Gina Raimondo kept saying during COVID, "This is not who we are." And I kept thinking to myself, what's that old Lone Ranger thing, Tonto? Who's this we're talking about?
Exactly.
It's not me.
Who's you talking about? Exactly.
Who's this we're talking about?
Yeah.
All right. I'm quite certain there's going to be a follow-up to this discussion. I just wanted to kind of set the stage today to discuss your thoughts, some implications.
You got to take the victories as they come, Mike, and this is a huge one.
This is a huge one.
You cannot understate how huge this is.
Look, and do you both agree that while we are not happy about this, saying it's huge because we feel any malice towards anybody or any group of people who may feel a certain way, we are defending our Constitution, and we are potentially clearing the way for confused gender dysphoric children to be saved through proper therapy. I mean, it's not, we're not happy because another leg of the woke agenda got chopped out, which it did. We're happy because we actually think we can save children in this, if they can get the proper therapy. And to me, that's the bottom line. Final comment from you guys, then we'll wrap it up on that rescore.
Ditto.
And again, great to see 8-1. I mean, Justice Jackson, we'll put her aside. 8-1. That's, you don't get many on a woke issue like this. When do you get that kind of agreement? That says something.
All right. Gregory Piccirilli, Suzanne Cienki, two of our great attorneys with the Law Center at the Rhode Island Center for Freedom and Prosperity. Thank you for your time today. I'm sure we'll have you back to talk more on this. Have a good day.
Thank you, Mike. Bye.
All right, and to you, our viewers, look, this is a big ruling today. There's going to be a lot more on it, but we had to get something out, figure out what's the proper course we're going to take. So thank you for tuning in, and we don't have a call to action for you yet, but stay tuned. So until next game, Mike Stenhouse out. See you then.